Susan, if you'd like to take it away, our Chair and President of Transparency International Canada, Susan Cote-Freeman.
Hi, everybody. Welcome back to day 2 of our week of dialogue. And James, before I forget, I want to thank you. You masterminded this whole series, so thank you so much for all the work and for, I know that you're having to manage a lot of back office issues while we're doing this. So thanks for all of that. Hopefully today will be totally smooth. Je vais aussi souhaiter la bienvenue à tous les participants et nos panélistes aujourd'hui. Merci d'être avec nous. I wanted to talk about yesterday just to bring those of you who weren't with us for yesterday's exceptional panel. We took a very sort of broad look at Canada's performance in the realm of anti-corruption. And if I have to summarize the verdict of yesterday is that we're not doing enough. The situation is not terminal. I think we have what it takes to do much better. And we talked about some of the obstacles. We talked about some of the solutions as well that might be, the need for more tools in our toolbox. But we also talked a lot about the fact that we need to have a more holistic approach, and we need for civil society, governments, and businesses to work together to sort of help us develop these additional tools. But I think the bottom line was that there's a lack of political will, that it's not a priority that's high enough on the minds of our leaders, and we need to change that. It's not an easy thing, but one of the things we want to do, or was suggested we should be doing, is also make this issue more real for all Canadians so that they can also apply pressure because they understand how it affects their daily lives. And I think what stuck with me yesterday was Drago Kosas, the chair of the OECD Anti-Bribery Working Group. He used a metaphor that I thought was quite funny. And he says he likens anti-corruption enforcement to a car. And he said, Canada has a good car, but it moves very slowly. And he said, we really need to rev up the engine. So that stuck with me. And I think it summarizes the sort of the discussions yesterday. And today we're going to actually home in on Canada's institutions and have a good look at what those are like and how they are sufficient or not sufficient to protect us against corruption. And just as a reminder, on Wednesday, we're going to look at the legislative and regulatory tools and see if our toolbox is complete enough. And on Thursday, we're going to draw some lessons from abroad, and we're also going to look at how companies and organizations are addressing this complicated problem of corruption. And on Friday, we're going to try to tie it all up together and draw some lessons from what we've heard this week. So before we begin today's discussions, I would really like to thank our supporters. And these are our Platinum supporters, Export Development Canada, Gold supporters, BLG, Blake's, Banque Nationale, Deloitte Canada, Dentons Canada, Sky Power Global, and Siemens. We also have Silver supporters, ACFO, Alessa, Kinross Gold, KPMG Canada, Thales Canada, and Groupe Vidocq, or Vidocq Group. Now, I must remind everybody that we encourage you to become TI Canada members or supporters. We need your support in order to carry out our programming, so it's really important to us. And as you probably know, these are difficult times for nonprofit organizations. I think we're all suffering from the issues that are stemming from the pandemic. So your support is really, really valuable to us. So I encourage you to become members and to support us. Before I hand the microphone over to our moderator today, I would like to introduce Daniela Chimisso de Santos, who is also a board member of Transparency International. Daniela is the principal consultant at Invenient Solutions Consulting. Daniela has practiced law in the oil and gas and mining industries for almost 20 years. She has extensive national and international experience, including in sub-Saharan Africa, South America, and Asia. The United Nations Development Program has recently recognized her as an extractives expert, and her last corporate position was Deputy General Counsel at Valley, a mining concern. Her publications include co-authoring Financing Human Rights Due Diligence in Mining Projects, Export Credits, Sovereign Debt and Human Rights, and Human Rights Due Diligence and Extractive Industry. So Daniela is also an expert in business and human rights. So Daniela, the floor is yours.
Susan, thank you so very much. Thank you so very much. Such a kind introduction. I am honestly delighted to be moderating this panel. We have an outstanding group of panelists today, and if I'm just going to take a few minutes to introduce each of them. So first we have Carolyn Hackett. She has joined the Serious Fraud Office Prosecution Division in July 2018 as one of its founding members. Prior to joining the SFO, Carolyn was an assistant Crown Attorney in the Peel Crown Attorney's Office, where she prosecuted major frauds and served as part of the complex fraud team, while also managing and prosecuting other major cases. Carolyn graduated with distinction from Western Law School and worked in a Bay Street law firm practicing commercial litigation before joining the Crown's office in 2007. Paul Garside is a partner with Vidocq Group, a specialized investigation and risk management firm based in Montreal, where he leads investigation, intelligence, consulting operations for major companies, institutional investors, and financial institutions. Prior to joining Vidocq, Paul served with the Royal Canadian Mounted Police over 2 decades, mostly dedicated to his passion, domestic and transnational financial crime investigations. Prior to his retirement from the RCMP in 2014, Paul concurrently held 2 positions in the province of Quebec, officer in charge of the commercial crime section, as well as the integrated market enforcement law. Paul has a bachelor's degree in applied law with a focus on law, criminology, and business administration. He also completed postgraduate studies in financial crime and Canadian securities officers. He's a certified fraud examiner by the Association of Certified Fraud Examiners. We also have Peter Dent. Peter is a partner in the Deloitte forensic practice with over 25 years of financial crime experience. He has worked in over 35 countries, and between 2000 and 2004, Peter was a team leader of the Forensic Services Unit with the Department of Institutional Integrity of the World Bank Group in Washington. Peter is very well known to Transparency International Canada. He was the past chair of Transparency International Canada, and during his time there, he released its first report on the vulnerability of real estate in Canada being used to launder the proceeds of crime, focused on the Greater Vancouver area. Peter has experience working with the United Nations, both with the UNDP and the UNPS. Peter is also a faculty member for 15 years with the Director's Education Program at the Rotman School of Management. We are truly delighted with this incredible panel and such an interesting topic with regards to the institutional framework in Canada and where we're at and if there's an issue. So I just wanted to start off by saying, as we know, ultimately institutions and institutional frameworks, they constrain behaviors, they are rule makers, they are the ones that abide for and not only create law, but also prosecute them and enforce them. Now, from an institutional quality perspective, Canada, as seen by the World Bank Worldwide Governance Indicator, has consistently ranked extremely high, especially with regards to the quality of its institutional framework, and specific indicators such as regulatory quality and other measures such as those related to rule of law have been consistently ranked high for Canada. However, recently we have seen some serious slippage. In the TI Corruption Perception Index that came out in January 2020, we saw that Canada has slipped actually 4 positions and falling from its perch of the top 10 countries. In the recent Export Corruption Report, we saw that in this report that analyzed 47 countries, Canada was considered to have limited enforcement, and that we were at par with Costa Rica, Argentina, and Colombia with regards to our enforcement measures. So when we look at this situation, I think that perhaps we can just start off our discussion. And yesterday they did talk a little bit about some of the scandals that have occurred, such as the SNC Lavalin, such as the WE scandal. But we thought we could just start off with some of the most notorious white collar crime in Canada and their repercussions, or actually we should say lack thereof. So perhaps if we can just have, just in general, what is your opinion? Do we have a problem? I'll start off with Peter. Peter, what do you think?
Well, I mean, do we have a problem? I mean, obviously it's an inflammatory title. Some might even accuse us of clickbait. But do we have a problem? Yes, we do have a problem. I think it's a well-documented problem. It's a problem we've talked about for many, many years now. And it's an institutional problem. Now, what I want to do is I want to go back and I'll just make, in terms of, if I was going to frame this in one way, I would frame this as through an example. And the example was that, about 18 months ago, I attended a meeting of the government of BC. I live in Vancouver now, but I attended a meeting at the government of BC, and they were amending the Corporations Act here in British Columbia. And just along the lines to keep it similar with the amendments to the Canadian Business Corporations Act. And under that amendment, what they're amending that the BC Corporations Act, similar with the federal legislation, is that now private companies must keep a record of their beneficial ownership. So if you can imagine that prior to these amendments, both federally and provincially in Canada, there was no requirement for a private corporation to maintain a record of its beneficial ownership, even for itself. So a numbered company, even for itself, needed not maintain basically a record of its beneficial ownership. And then you take that to the next step and you say, okay, so you've now maintained a beneficial ownership record, but in terms of having publicly available access, there is none. And if anybody wants to research who the beneficial owner is of a private company, including law enforcement, including regulators, including financial institutions, they have to go to that corporation itself and request access and them to verify who their beneficial ownership is. I mean, that's a step forward in Canada. Now, if we think that we don't have an institutional weakness problem in Canada, that is our best example that we do. Up until 2019, we did not have to disclose or maintain records of beneficial ownership, even for a private company itself. So I have a private company. Now it's easy for people to track it down because the private company is in my own name. It's Peter Dent Professional Corporation. But when I walked in to register that private company, I could register that private company on my own in the province of Ontario at the time. I did not have to produce identification. I could do that. Now, in order to set up a bank account, then I had to go into a bank and produce identification and then attest that I was the owner of that corporation. And look, I'm telling sort of a long story here, but it's harder to get a library card. We say that in one of our recent reports around beneficial ownership. But Great.
Sorry, I think Peter might have, sorry, Peter, you froze in the last finishing off comments. If you could just repeat that, please.
Okay, so I was just saying that it's more difficult to get a library card here in Canada, and that I'm going through this example in detail just to give the perspective that it is the best example, or one of the better examples, of how there is an institutional weakness in Canada around transparency in terms of who you're doing business with. But I'll leave it there with respect to my opening comments.
For sure, thanks, Peter. So Carolyn, from where you stand, how do you view the recent scandals and any sort of case that comes to mind, and perhaps the lack of consequences of that?
Well, I think that this is actually a really exciting time to be working in an institution in this space. And obviously the comments that I make today are my own and aren't on behalf of the ministry or anything like that. But for me, it's a great time to be working in this particular situation because I think that there is now political will, or we can see that even in the establishment of our office, right? So the Serious Fraud Office is a new office, but it really is a holistic approach, which we know is something that is required in order to combat financial crime. And so our office is essentially established in order to deal with the problems that might have existed in the past. I think it's frustrating for a lot of people when they see essentially large, blatant financial crimes that seem to go unanswered or unprosecuted. But really, we have to, ask the question, why is that? And, perhaps there hasn't been one agency that either, has had the jurisdiction or is willing to assume the jurisdiction in order to take on the multi-levels that are required in order to combat financial crime. And so here we are with the Serious Fraud Office, offering that approach within Ontario. So for me, while it might be a frustrating time period, it's actually a really exciting time period because here we are to offer the next steps in order to combat financial crime.
Excellent, thanks, Carolyn. So we have, Peter gave us a clear example of an institutional weakness. We have some examples that Carolyn has mentioned with regards to a lack of mandate, and perhaps now an exciting moment in which there are creation of new institutions. But just going back to the positioning of where we are right now and recent scandals and lack of prosecution. What are your views, Paul?
Well, I think it's a hard record to defend. I mean, we have numerous independent experts that look at the results, look at the money. I mean, we're talking huge amounts of funds are going towards investigators, investigations, and prosecutions. And at a certain level, it's about accountability. And what are people getting for this? And that's where sometimes it's hard to defend. You see a series over the last couple of decades of, you have Brex, you have more recently Valiant or Sino Forest, and these things kind of have a slow death or don't go anywhere. And people ask questions, and rightly so, because we're talking about a lot of taxpayer money. And the typical responses that you hear as well, it's a complex case. So we couldn't get access to the required information. And there's some truth to that. I mean, like in Sino Forest in China, obviously extreme difficulty. You also often hear, well, we need more laws. We need more tools. But I think that it avoids the real issue. For me, having worked in the RCMP for many years, having done these investigations and having managed them, I think that the RCMP and other agencies can do these things and can do it well. And there are some really good success stories out there. And before I talk about my criticisms of the RCMP, I think we also have to look at what the RCMP does well. And there's cases like Noble, like the Canada Revenue Agency corruption case. A lot of convictions there, complex case. This really impressive recent case, a collector by this sergeant here in Montreal, who had a really impressive number of charges against these international money launderers. So I think whether it's the RCMP or other agencies, the capacity is there. They're smart people, they're dedicated, hardworking. Now, the challenge I saw is structural and cultural. So to go back to the car analogy, that the car is not going fast enough, I would say, well, the RCMP at least, they're very good at building SUVs. We have a lot of SUVs, and RCMP is a generalist police force, and they have this culture because most of the RCMP doesn't do high-level crime. They do provincial policing, essentially, rural policing. And so it's a generalist culture, which builds these wonderful SUVs. And what we need is like Formula Ones, and for these cases, which are very complex and high-level. And to build those Formula Ones, that takes time and resource dedication. And that's where, unfortunately, a lot of times the RCMP, it hits a wall. You don't have that culture that allows that long-term expertise development.
For sure, and I think, yeah, go on, Carolyn, sorry.
No, I was going to jump in there and say, the SFO at this point wants to be that Formula One. And I think that we really have the capacity to do that. We are a newly and uniquely structured institution, in that never before have there been, access to prosecutors right from the get-go in the same sort of way that the Serious Fraud Office has. We have this integrated approach where there is the investigation branch within the Serious Fraud Office, the prosecution branch within the Serious Fraud Office, and then the adjunct and support services. So while having all of that, so to speak, under one roof, while still maintaining the independence of each of those arms, it really is a new way of being able to tackle the types of offenses that we look at.
What I like about Carolyn's, I think it's fairly new, right? Your Serious Fraud Office. What I like about it is, unlike IMET, you're going to do more broad, high-level investigations. IMET was always this thing of, well, is it a market offense or market crime? So often it gets involved in semantics and jurisdictional battles. I like that's more broad. I think your biggest challenge is going to be get the right people, and not only get them, but have them stay there. These are things like, if you look at the Nortel case, it was an incredible rotation of investigators and prosecutors. And that's a recipe for disaster. You can't have that. If you're going to have a serious investigation team that hopes to get convictions in these cases, you have to have, at the ground level, people with experience. And I mean also prosecutors, because prosecutors are often forgotten in this whole thing. And often you see the game of police blame the prosecutors blame the police. And for the most part, I think that removes the larger issue, that whether it's a police investigator or a prosecutor, you need good people. And I've seen this. I've seen prosecutors on board that made the case and prosecutors that ruined cases, either in the investigation or the prosecution phase. And again, to me, that goes back to skills and experience. And you have to be able to build that. And that takes time. And so that's the biggest challenge, is getting the right people and keeping them there and not having them constantly move on and leave other sections or other duties.
I think we've been really lucky in our office, especially, or even being a newer office. We started truly in the fall of 2018 with the hiring of essentially all Crown attorneys who've had pretty much 10 years experience at least. So that's really beneficial. And this idea that you have a Crown who is assigned right from the beginning in the investigative stage really enhances the responsibility aspect of the Crown attorney, because I do understand what you're saying, and I think that that's a common comment that's made. But here we have a situation where Crown ownership of a file and accountability is truly part of the way that the whole office is set up. If you have a Crown who has to make decisions at the beginning and then has to defend those decisions they make, it increases the likelihood that they're going to give careful consideration to them at the outset. And of course, we're always, mindful that you can't, develop tunnel vision just because you've been there from the beginning, but rather there's this continuous assessment of, reasonable prospect of conviction for down the line.
That's a very good point too. I think people often also forget that. I often say investigating is like building a house, and a lot of these major disasters I see at the front maybe shouldn't have even been started. Because if you've got to build a house, you've got to look, is the ground sound? Can I build a house here? And I often say at day one, if you don't have a case theory that you can explain to a 12-year-old, there's a problem. And I've had this in the RCMP. I remember having arguments about these high-level cases, and after seeing a presentation, and I was like, where are you going? Where's this going? And there's often sort of a blinders that the train's going down the tracks, we've invested the resources, we've had a press release, we're doing it, and there's not that vision of where are we going to get to and what is required to get there. Is the evidence available? Like you say, is there a reasonable prosecution potential or a conviction potential? And so that's a very good point. You have to really build it at the front. And a lot of time in the RCMP, I actually had to push back against, as an officer especially, against the pressure to investigate certain files. Why? Because they are complex and they are involved, and you only have a certain number of resources. If you assign resources to one file, you might not have enough for the second over a number of years. And so I think that's also very important, is to look and have, against experience, do you know what you should start and what you should not start? And yeah.
So I just want to pick up on something that Carolyn, you said, and Paul, you sort of talked about, which was the reasonable expectation of prosecution. We do know that there are barriers in Canada that prevent the reasonable expectation of prosecution in transnational crime cases. Sino-Forest has already been mentioned. That is a good example of where a Canadian legislation precludes that, and especially if you look at money laundering cases. Money laundering cases require us to prove in Canada the predicate offense. So we need to be able to demonstrate that money laundering actually occurred. We know that in the real estate sector, from the studies that we've done, many of the predicate offenses for the money that's washing through Canadian real estate actually take place outside of Canada. And because there is not that capability to look at financial crime outside or extraterritorial or capability, and because our money laundering legislation requires us to prove or demonstrate the predicate offense, I think that is basically a weakness, an institutional weakness that we have in Canada that we can only be fixed through legislative changes. The other point I would make about the reasonable expectation of prosecution is that collectively it has resulted in many high-profile cases not being taken forward because the Crown views there to be a poor reasonable expectation of prosecution. And in many cases, unless we demonstrate basically lay bare that these are the reasons why this case was unsuccessful, there is no political pressure to change the legislation or change the laws in Canada to make it easier to prosecute these cases. And so I will only just point that out, that somebody said you can learn more through failure than you can through success. But I think collectively, Canadians need to see these cases brought forward, and if they fail, why they fail.
These are great points. I just wanted to go to our questions from our audience. So we have a question from Pooja Chaudhry. Do you think Canadian companies are doing enough on the proactive fraud risk assessment front? And given your practical experience, do you see the shift from preventive to predictive analysis coming in effect?
So I'll take that first. From a fraud risk, this is something that we do. I do quite regularly, is assist companies or the public sector with respect to conducting fraud risk assessments. I would say that there is great progress being made on the private sector side around the implementation of fraud risk assessments. But that is when I talk about that is the most sophisticated clients. So we're talking about banks, we're talking about large manufacturing entities, we're talking about large oil and gas or energy sector mining companies that they view fraud risk assessments as a bottom line activity. It's something that assists them in controlling costs because fraud is a cost to their business. But when you go below that level, then the actual activity of undertaking a fraud risk assessment, if there is not a regulatory requirement to do so, as there would be for a publicly traded company, then there isn't as much interest in doing it because it is viewed as a cost to the business. And that happens in public sector institutions as well. They don't take these fraud risk assessments as seriously. So I hope that's a helpful answer.
We work a lot in this space, large corporation clients, and our view is whether it's any sort of prevention initiative or risk assessment, it has to be real. We are really against the box checkers. And unfortunately, I see too much in the industry where people do this sort of surface prevention, anti-money laundering, fraud risk, corruption risk, and it's to get certified or whatever else. And it's a lot of times it's not real. They don't ask the real questions. And we've actually even had clients come to us and want us to modify reports because we found some risks and we outright refuse. But I know some other perhaps firms out there would be more comfortable with sort of whitewashing certain risks. So I think that's the key. Is it a real risk assessment or a real fraud prevention or corruption prevention, right? Or is it just playing the game?
Yeah. So we have one more question. I think this one is directed to Carolyn, and it's from Alan Frank. And the question is, I have been involved with numerous investors who were defrauded of hundreds of thousands of dollars in the syndicated mortgage industry. They have sent emails to the SFO on numerous occasions. I have copies of those emails, which have gone unanswered. So to what extent is the SFO actually functioning to help with fraud in Ontario?
So, I mean, this is probably not a forum to discuss specific cases.
Absolutely.
So I'm not going to do that, but the SFO is, of course, fully functioning. You know, the intake procedure goes through police services. So the way an individual from the public would make a report to their local police service, and then it then travels through the intake process to then make its way towards the SFO if it's a case that falls within the SFO mandate. I think that's the best answer I can give at this particular point. So, you know, follow up with their particular police service and see what stage they've gotten to.
But Carolyn, as we were preparing for the panel, we were talking about some success cases, and perhaps it'd be great if you could share with us sort of a recent success case of the Serious Fraud Office.
So the Serious Fraud Office, as I said, has multiple branches to it. So there's the investigative branch, which are the police service aspect of it. And then there is the prosecution branch, which are the Crown attorneys, so to speak. And because these are obviously long investigations that take a long time to put together, what we've been doing as the prosecution branch is also prosecuting certain cases that have been within the criminal justice system already, and assisting other offices within the ministry to do that. So, for example, we've had in the past year, and of course this is a funny year because of COVID, 2 cases that resulted in convictions. For example, there was the case of Mr. Vanier, which was an investment fraud, and had a 2-month French trial that Crown attorneys from our office ran, and he was convicted and sentenced to 8 years for his participation in that fraud. It's currently being appealed, as many of these cases are, but that was the result at trial. Just recently, there was the case of Mr. Rutenberg, and I think for those of you in Toronto Life just ran an article about him, where he was just the prosecution was done by a member of our office, and he was just found guilty and sentenced to 6 years for his participation in a romance scam. So those are 2, you know, very timely and specific examples of how the prosecution branch is continuing to prosecute matters currently within the courts. There's also a number of matters that are in the in-between stage between the findings of guilt and the sentencing stage, and those will come to fruition in the next few months.
For sure. Well, that's great. Thank you. I wanted to just go back to, you know, to the institutional framework in Canada and where we stand today, because sometimes I wonder whether we could take a more positive outlook, in the sense that there has been quite a lot of movement with regards to institutional creation, right? We have created UPAC, we have created, which was in 2011, the Ontario Serious Fraud Office, which is in 2018, the BC Beneficial Ownership Registry, still not at play, but theoretically it will be at play quite soon. So there has been some institutional movement in trying to fill certain gaps. How do we need more institutions, or do we just need to do better with institutions that we already have? Do we need to just throw money at them, or specifically, you know, how do we look at this institutional framework where new institutions are being created? We already have institutions that have been acting for, you know, decades. You know, how does this framework work, and where should the action actually be?
I think that these are some joint task forces, whether it's in Ontario or you have in the UK or UPAC. I mean, despite all the criticism we've seen recently, UPAC, they still had a lot of success, and I think the model is not essentially wrong. I think it can be very effective. For me, I was looking at the OECD report yesterday, it was mentioned, and the 4 countries that were rated as doing the best in this area, and I think it was the USA, UK, Israel, and the Swiss, I believe. And what's interesting about those 4 countries they have in common is they all have a dedicated team or teams to this high-end type of financial crime world. And for the most part, they create a separate sort of unit. And I think the key on all those teams, what I've seen, is independence. Independence from political pressures, independence from an HR standpoint, to be able to go out and get the right people, give them the proper training, proper compensation. And I think that's what's required to build that kind of niche expertise. And that model has proven itself. So it's not about, to me, about doing more, putting more groups or pouring more money into it. Because I mean, we know that government can be a sort of a endless well of asking for, for more resources. I've been there. People never say, come cut my section. No one's going to say that, right? They always, I need more people, more people, more people. And so to me, I think you should build it right. Build it right, whether, now the whole debate with the RCMP, whether it can still be done internally or not, there's opinions on both sides. I kind of came to the opinion that maybe the RCMP should create a separate federal agency, not have that kind of dependence on the larger part of the RCMP, which is all oriented towards frontline policing.
Mm-hmm.
So yeah, I think that's what they get to. If they get to independence, you have to build a structure where they can pick who they need to do the job, where people can grow there for a number of years. And even the good prosecutors, my best prosecutors, they end up being judges. So like, that's great for them, but not for us as investigators. We want to keep them. and the same thing in police world. I mean, people do really well, the best investigators, they get their promotion and they move on somewhere else. So you have to build that kind of capacity where people can do a whole career. There's one last point. Sort of like the FBI. I know the FBI has issues too, but they have a model that's not paramilitary. It's all a pay grade with numbers. So for example, you can work up from number 1 to 15. And at 15, you may be running an office or a section, or you might just be a good super investigator in some niche thing. And you can spend years doing that. So whereas like the RCMP or other paramilitary agencies don't have that. You're forced a lot of time to move around from section to section. And even, unfortunately, because of that paramilitary structure, people who enjoy doing investigations, who are good, and they don't want to move the ranks, they want to stay corporal or sergeant, they're almost, from a cultural standpoint, not respected. They have an expiration date because, okay, now you've done so many years and you haven't moved on. You haven't, what's wrong with you? And maybe nothing's wrong. Maybe they're just a really good, smart investigator, and they enjoy what they're doing. So to me, that the devil's in the detail. You have to build these structures that have that promotion and retention of experience.
So I think I agree with what Paul's saying. I agree with you, Paul. I think you're also arguing for it to be built separately outside of the RCMP. If you try to create a separate division, where are you recruiting those people from? And where do those people go back to? And where is their upward trajectory, but if it's not within the RCMP?
Well, I can answer that.
So
I mean, where does any other agency get their people? Where does the
other people are getting their people from their agency are recruiting them separately. So they're recruiting based on talent. They're based on what their requirements are. They're not recruiting them out of the police. And so
that's not true.
Well, I'm just saying that if I could just finish, Paul. So because I think we're saying the same thing. I'm just saying I think a better argument would be to build that outside of the RCMP. And to design that in such a way is that I'm not saying it's not a law enforcement agency. I'm just saying it's not attached to the RCMP because of the history and culture within the RCMP. The question is then you're recruiting talent based on what the needs of that talent are. And so, and depending on what your needs are in terms of the types of investigations that you're doing. Plus, as you say, you're creating a trajectory in that area itself that has a recruit level experience, a mid-grade level experience. You can go down different paths. You can create this sort of governance structure as you said, suggested, that somebody can be a specialist and work as a specialist their entire career, but somebody that wants to go through management or administration can move up that career as well, but still stay within that agency itself. So I'm only arguing that your recruiting is based on different standards perhaps as well, much like the FBI has different standards in terms of expecting a CPA, a law degree, an MBA coming in as basically being table stakes to what their expectations are from an education standpoint. So you're creating different sort of governance structures from a standard policing organization, a traditional policing organization, to this specialized functional unit that is only going to be interested in transnational economic crime. So I'm not disagreeing. I'm just saying from a structural standpoint, I think it would be more successful if it wasn't attached to a historical law enforcement organization.
Okay, yeah, I have to
so,
actually.
Sorry, I don't mean we can continue with this conversation, but we have so many questions in the Q&A that I think that, you know, let's park this one and let's just take a few other questions here. There's one for Paul specifically, and it's from the question is for Paul, and it's from Paul Lalonde, and the question is: I hear you on box ticking exercises. How do you feel about ISO 37001 certification? Is it meaningful, useful, or just a box ticking exercise?
Yes, that's a good question, and I don't want to comment specifically on theirs, and there's many others. Again, I just think, as I mentioned before, devil's in the detail is how the exercise is done, and is there a real internal volition of that company to actually put in place these processes, or are they just going through a process, checking it off, and moving on, and not having that sort of follow through and overall sort of desire. Right? I mean, I remember one case. This company had been certified. I won't say by who, one of these certification agencies, and they were a corrupt enterprise. They were a criminal enterprise, and they were laughing as they put up on the wall their certification. Say, ha ha ha! Look what we got, and they were essentially a criminal organization. So I think that's the kind of thing we have to avoid. I mean, if these certifications can guide people to a process and to an awareness that actually prevents corruption and fraud, sure, but you gotta take that one extra step. Just to, if I may go back to Peter. Actually, Peter, I think I actually agree with you that at this point, maybe the RCMP, it can't be attached. And the way I say that is because of my experience with IMET. IMET was, if you recall, about 20 years ago, an attempt to create a subgroup that was protected with a separate budget and separate agency and separate recruiting. And it was not the same agency, but it's all separate sort of human resources that you could get from the RCMP, but were untouchable. Well, it didn't last. It was almost doomed from the start. Bit by bit, that separate status was against the culture of the rest of the RCMP. So you saw bit by bit, the budgets were combined. And I know they say, well, we'll combine the money we have from Finance Canada with the rest, and you'll get even more value. And then we'll do the math to be sure that that money is still going to IMET. I lived it. An example where we had our own major case management team. And I know Carolyn knows how important major case management is when you disclose the stuff, right? It's critical. And we had a great in-house major case management team. And one day, some people from our headquarters said, oh, well, why don't we combine the resources? We'll take your major case management, put them with ours, and you'll get much better service. And it was almost like half and half. They had about the same amount as we had. We had big cases. And I fought against it, lost the battle. They got absorbed. And the day after, the people that absorbed them gave themselves promotions because now they're managing more people. And the very next case we don't do a lot of these big cases. I'm told, well, we're not sure we can support you. We don't have the resources. And then with our in-house team, we also had the ability to really sort of tailor our disclosure as we needed for our case. And then we all, again, got pushed back because it didn't fit the vision of the other team. So again, it just shows that whether you build it in-house or separate, you've got to be sure there's a firewall. And I think, Peter, you may be right that there's no firewall strong enough against the culture of that generalist policing right now. There were times in the RCMP when we had these hubs of experience. They go back 20, 30 years, whether it's proceeds or bankruptcy, there were, but over time, the culture of generalist policing took over. But I just want to say one last thing is that what I thought you were referring to actually a lot, Peter, is that people say, well, if we make a separate police force, where will we get our experienced investigators? Because the only way people become a good federal investigator is if they do the frontline policing. And I think that's kind of a strange comment because you could recruit them from any other police force. You can recruit them from the UK, the FBI. You could recruit academics. You could use civilian investigators like the UPAC's now going to do. And that too, I think, is very promising. So I think when you're separate, you can get more creative and you can build these really powerful teams. And the last thing you want to do is surround yourself by clones, right? And so if you do have that independence, you're able to do kind of a more broad spectrum of experience, which can be really beneficial.
Absolutely. Carolyn, did you have Did you want to add anything?
I was going to add that I think, yeah, that right now we do see a little bit of the independent, shops in the sense of, regulatory, like the new FISRA or the OSC with their JSOT team as well. And so you do have those independent entities that are dealing with more regulatory offenses. And I think where it becomes interesting is how do these all interplay with each other? A lot of what the SFO does is reach out and create partnerships with other entities. And of course, there's always the issue of, information sharing within a permissible framework. And so right now, at least the SFO has been really trying to, enhance those partnerships in a permissible way, obviously, with regard to the charter, et cetera, but making use of the institutions that are already there so that we can continue to be generalists, but also lean on the expertise of those individual sectors.
Don't get me wrong. I don't think you need all experts or no generalists. I think that it's a question of degree. That's like 30% or 50%, because you're still going to have these rover investigators you need to bring on for a period of time. But it can't be that most of your team is the rovers and don't know what they're doing, and only have one or two experts. Like, I've seen that model, unfortunately, in the RCMP, where we have one or two experts. It's not going to. You have to have that critical mass of experts. I would say even the private sector, the same thing. I've worked on occasion with some of the big accounting firms and law firms who are in this investigation space. And guess what? You have people like Peter here, who I know is for Privatization, and I bet him is obviously, I would put in the high expert level, has experience, knows what he's doing. But what also happens in investigations, you got to bring in all these soldiers, whether accountants or lawyers, and they don't know what they're doing a lot of time in terms of an investigation. They know their law or accounting, but not investigation. And that's a challenge. That can cost a lot of money to clients, as much as in the RCMP or policing world, you have all these investigators costing a lot of money to taxpayers. So I think there's a parallel there in terms of even in private sector, it's hard to get that experience and to build that capacity.
I think what's and I'm going to plug the SFO again, but what's interesting about our structure is that third prong, which is that adjunct and support services, which has a focus on training, both internal and external training. So we are creating our own expertise from within. So you might take a generalist and then make them an expert because you've homegrown, so to speak, and train them into to someone who now has the expertise. And as I said, we lean on partnerships with other people, including the private sector. Right, because as we prosecute different types of frauds, we require information and assistance from the private sector to teach us, because we become experts as we do. And I think that is one of the best ways to hone your expertise. And it also creates a sense of teamwork within your own entity, which causes people to stick around and they're not looking to go elsewhere, because you really do take ownership of what you're doing. And feel a great sense of pride in becoming an expert in your particular area. I think as lawyers, we tend to be generalists, and then as we progress, you do develop, perhaps multiple expertise in different areas, and that can really only assist, especially in a prosecution where we're expected to be experts in all sorts of different things, depending on the case that we pick up.
For sure. So I just wanted to go back to the questions, because as I said, we do have quite a bit of questions. So we have a question from, so we're going to change a little bit course here. We have a question from Jean-Pierre Chabot, and the question is there a higher risk at municipal, provincial, or federal levels for fraud, graft, kickbacks in Canada? And at what level are the regulatory legislative gaps that would support prosecution most prevalent?
That's a good question. Yeah, it's with fraud, there's a huge dark figures that were underreported, because people know, especially the smaller frauds, they're not going to get the results. So I know just here in Montreal, you have literally thousands of cases that are reported and never even touched. And even beyond that, there'd be many more that are never reported. If we look at corruption, I know there's all this emphasis about international corruption, which is a serious problem, obviously. But I think we often forget the elephant in the room, that what's actually more damaging to the average citizen here in Canada, and it's probably more local corruption. And I know Quebec's been very effective in exposing that and shining the light on it, and then you have with the Commission, and then UPAC, or before Marteau, following up with the prosecutions or the investigations. And I wonder, like Ontario and other cities, is there a lot more of that dark figure corruption fraud is not being investigated or reported? And I think the answer is yes. In terms of risk, it's you're going to lose money anyway. You're going to lose your reputation as a country, as international, right? It's all bad stuff. But what affects individual citizens more is probably, it's your local contractors building your road in front of your city, and you're paying twice the price. That's probably going to hurt people much more in their pocketbooks in terms of their livelihoods.
So let me add a different perspective. And I'll go back to the question. They're talking about public sector. Is the public sector more at risk? Let's make it real. Let's talk about COVID-19. So what happened in the public sector in COVID-19? Well, they started procuring goods and services at an unheard of rate. So their procurement processes in the public sector were not designed for the level of procurement that we undertook since February. So they may be procuring billions of dollars of goods and services on a regular basis, but all of a sudden they're procuring tens of billions of dollars of goods and services on a regular basis. And a lot of their internal controls had to be put outside, thrown out the window as well during this time. And where were they procuring much of this good? So let's just talk about PPE, physical protective equipment. And so that wasn't being procured from within Canada. That was being procured from the dark red countries on the TI corruption map. And so there's a high risk of those types of procurement. So, the one thing about public sector funding is that if there is evidence of criminal activity, and that points towards criminal activity, I'm not here to tell you whether it was criminal or not. I'll leave that to the courts to decide. But if there was evidence pointing towards criminal activity, then that would be reported to law enforcement because it's public funding or it's public sector monies. The difference in the public sector than the private sector, because in the private sector, they just don't report it. They don't report it for a lot of reasons. They don't report it for a brand and reputation issue. They don't report it because they don't view it as being taken into, basically they don't view with a high degree of credibility that it will actually move forward through our criminal justice system. So there's all sorts of reasons in the private sector, but the public sector, they don't report it if they don't want to be embarrassed by it politically. And so can you imagine that we were procuring tens of billions of dollars worth of goods and services from the darkest, reddest countries on TI's corruption? So we're going to have to wait and see how this unfolds going forward. But that's the only point I would make, is that that is a real risk in the public sector, and I would say that is a really high risk. But my experience is that unless there's compelling evidence, there's an unwillingness to turn over the rocks.
Carolyn, any thoughts on anything would you like to add?
Well, I think that underreporting is notoriously a problem in fraud and financial crimes. I think it's very hard to quantify how much fraud there's out there. We just know that there's a lot, basically because it is not reported for a variety of reasons. Work with a police service where if a fraud or a crime isn't reported, there isn't much to do, right? So we obviously want to encourage as much reporting as possible. And I mean, that helps us too with the education programs that are being put out to encourage people to report financial crimes when they become either victimized by them or aware of them.
There's an interesting, from my clients, we sometimes advise on, well, what should I do if we do come across something internally, a corruption, say one of our persons here overseas has paid some bribe, for example. We discovered this internally. If that ever happens, what should we do? Should we report it to the RCMP at their section in Ottawa of what's it called, International Intensive Investigation? This is a section that investigates these things. And what we often tell clients is that if you do find it, you do your first internal investigation, find out how bad it is, and you're probably better off, generally speaking. I mean, it's debated, making the first step and self-declaring, and having at that point a process. So the RCMP will do an investigation based upon that, and it may finish with a DPA or not. But what's interesting, I hear back from clients of large corporations at least, is, well, oh, I don't really want to do that. I don't really feel comfortable ever going to the RCMP. Well, why? Well, because what if the cavalry shows up? Like, they're going to either do like a media thing, or they're going to show up with their license sirens, and they're going to embarrass us, and the company's stock will go down. And so there's this fear that if they come forward and report it, that it'll be detrimental. And which they don't have, unfortunately, Canada, is the fear that if they don't report it, it's going to be bad. They're like get caught, because they're not dumb, right? These in-house counsel people, and they know that if you look at only a handful of these convictions for international corruption, they think, well, what are the odds that the RCMP is going to come after me if I don't report it? So we're going to need to get
Paul,
to the point.
Yeah, no, I just wanted to say that you touched upon exactly the next question that we have from our audience, which is from Jennifer Quaid, which says, a lot of concern stems from the perception that large organizations are rarely held to account because trials against them are very difficult, and the convictions, whether pleas or convictions after trial, are rare on charges of corruption or foreign corruption rather than fraud, which does not carry the same stigma. Is there a credible threat of accountability for these offenses for large organizations? RAs have yet to have an impact.
I think in Canada, it'd be hard to argue that there's a high risk right now, because we're not seeing a lot of results or capacity in terms of. So I think that's one place Canada is going to have to get there, to where the US is, where the UK is, where the Swiss are. You're going to have to get to that point where there's enough fear in corporations that if they don't come forward when they discover the skeletons in the closet, that the damage following will be worse than sitting back and just ignoring it. And right now, unfortunately, well, I shouldn't say ignoring it, but just putting a cover over it in the house, right? Maybe fire somebody and move on. So I think that's the really key we have to get to here. And right now, from people I talk to in the private sector, I don't get that feeling there's that fear level, because they're looking at the results. So it's a bit like, sort of a chicken egg thing. You have to get the capacity up to get more reporting in and self-reporting. I'd also like to see also whistleblowers too. We don't see a lot of that. I mean, the handful of RCMP cases, they were often handed a bit like a plate, right, from another law enforcement agency, or some that were self-reporting from the entities. I'd like to see also whistleblowers more comfortable to pick the phone up and call the RCMP in Ottawa and say, look, I'm seeing this. You should be aware. And we're not seeing enough of that. So that has to change. And whether it's going to take a separate organization, a separate federal police force, I don't know. But there has to be a shift there from the public.
So I don't think that that a separate, you can't change. The only thing that we've seen move the dots around whistleblowers in terms of their propensity to call is rewards, monetary rewards for whistleblowers. Not even the US saw that needle move much in terms of whistleblowers coming forward, and until they enacted monetary rewards for it, because the outcomes for whistleblowers are just so poor. Mm-hmm. And that there really is no upside. There's a great study done by Rotmans and University in California that talked about outcomes for whistleblowers, and I think it was entitled "Who Loves a Rat?" And the answer is no one. So even in peer groups where the outcomes of the whistleblower for that peer group are positive, so the peer group actually did better after the whistleblower came forward, the whistleblower was still shunned. And so there is human nature not to like people that blow the whistle. And so therefore, I don't think you're going to get many positive outcomes until we see some sort of changes around monetary rewards that are comparable to the losses that whistleblower is going to incur. So a $5,000 whistleblower reward is not going to compensate for the destruction of somebody's career because they blew the whistle. But
yeah, I think it's a very valid point. You're right. Almost no whistleblower turns out well after, and it's unfortunate. And that's, I say the same thing if you have people involved in organized crime cases. If you have someone who's a witness protection program, it's never an easy thing to live with following. I also would think, though, if again in Canada we had stronger results in terms of people receiving serious sentences. And because the reality is these whistleblowers are often part of the scheme, right? They're involved. And I think a whistleblower, a lot of cases in the US or UK or whatever else, where they have a strong sort of response, if they're a co-conspirator, they might have that fear that maybe they should make the phone call. And I see someone's putting the phone call and the phone number for Ottawa in the chat, so I think Ottawa wants people to call. But you're right. Yeah. Please call us.
Carolyn, I wanted to make sure you had a chance to comment. Sorry,
Thank you.
Carolyn.
No, thank you. And I think that the tide is changing. I think that there really is more appetite now to put the resources towards the, investigation and prosecution of these types of offenses. I think that the creation of our office really does show that we are taking steps to, to create something new and different that will have a holistic approach to fighting these types of crimes. We do see, like, for example, for the matters that do go through the court and result in convictions, the sentences are pretty high for Canadian standards. And we're seeing people who are convicted with fraud routinely get, mid-level penitentiary sentences, which are some of the more significant sentences for people who are convicted of crimes in Canada. So I think that there is the appetite there now. And as I said, right from the beginning of this, it is a really exciting time to be working in this space.
So you actually mentioned something that has just come up in one of the questions from Denis Munir, and he talks about financial crime offenses. For example, fraud in the criminal code carries a maximum of 14 years. With good behavior, the convict serves only a third of the sentence. When millions are used to bribe corrupt officials, is the sanction sufficiently high in this situation, given the harm done to society and trust in our institutions? So I guess there's a questioning whether the offenses actually do carry sanctions that are strong enough. So in your opinion, they are strong enough, Carolyn?
Well, I think that we are, confined by the limits of the law, right? You are working within Canadian law. We often see, sentences in the United States, which are, right next door, and they are attracting, many, many more years. But it's a very different system with regard to sentencing. The fact that, fraud now has a maximum sentence of 14 years, that's quite significant. That was an increase back in 2004, but that is a significant increase. It used to have a maximum of 10 years. There's currently a mandatory minimum for fraud over $1 million, and that's 2 years jail. We have to remember that within Canada, mid-level penitentiary sentences being the norm for even first-time offenders, those are significant sentences. And in Canada, fraud will often attract some of the higher sentences that we're seeing.
Anybody else?
I think that getting caught, the chances of getting caught outweigh any kind of harshness of penalty, and so I think that's what we have to see more. It's just, even if everybody all got probation, I think if we got to a point where we get a lot more convictions and traction in terms of those numbers, that would be very effective, as opposed to putting people in jail and throwing away the key. I think it's more important to have a very high likelihood of being caught.
I think that makes sense. I think we have to remember, what our sentencing regime is in Canada and what it's based on, and, be mindful of that when we compare it to other countries that have very different approaches to sentencing. We are not a throwaway, lock the door and throw away the key type of society. And so you're not going to see the same type of sentences here that you would in other places.
Great. So we have another question now from James Cohen. Could you reflect on how our federated system affects our institutional mandates and capacities?
So
is there a problem there?
Yeah, so yes, there's a problem when we have so many different regulators in Canada. It makes it difficult to navigate the regulatory environment. The Securities Commissions is the great case in point. There was a movement a few years ago to try to nationalize the securities regulator. That's kind of stalled, and so that would be a great thing. So we don't have a system akin to the UK or the US where they have a national securities regulator. So you're navigating all of these different securities regulators in terms of especially in the world we live in, which is borderless for transnational crime. And that's a big institutional weakness that we have. And then you cascade that down to what are the provincial responsibilities? Because, you know, talking about beneficial ownership, transparency, then you've got another problem in that you're basically all of these registries are managed right now. The company registries are all managed provincially. There is a federal registry as well, but so you end up with all of these different registries that you need to navigate and have an agreement with in order to share data, share information, even create that national registry. I fear that we could get bogged down in the discussion of a national registry, much the way that we got bogged down in the discussion around the National Securities Commission as well. So those, yeah, it's a stumbling block. It's a stumbling block that you have to navigate all of these things across borders. It creates barriers for business. I mean, these are just natural business barriers as well to any company that operates across the entire country, and especially publicly traded ones that have to navigate all of these different relationships. So yeah, it's a problem.
Any other thoughts on this? So now I just wanted to touch base a little bit, something that we talked about this offline, and I'd like to sort of bring it back. So this idea that we have public institutions and a public institutional framework, but there's also an entire private side to this discussion, which is the private side investigations aspect of it. And I was hoping that we could talk a little bit about the differences and sort of the privatization of the investigation of white-collar crime and how that affects the public domain.
So as I built my career around private sector investigations. 99% of my investigations never touched law enforcement. And it's a relatively small community in Canada. So I know those that work at the smaller firms, that work at the firms similar in size to Deloitte. And the story would be the same for all of us. Very few of us actually see the criminal realm in our work. Even though even myself, I came out of a policing background, I rarely see this going back. And so in Canada, and for years, if I talk to private sector individuals, the biggest complaint about making a complaint to law enforcement is that nothing will happen. And so we need to deal with this problem. We make a complaint to law enforcement and nothing's going to happen, or else they're going to ask us to delay our internal investigation or what we need to get done to move our business forward while they conduct their criminal inquiries. And so many times they just say, we're not, whether right or wrong for their reasoning, but many times they just say, we're going to do it from a private sector standpoint because we can't take the time that it would do to go through the criminal process. And that's a legitimate argument from a business perspective, but it does nothing for us to understand the true nature of financial crime or transnational crime in Canada, because the vast majority of private sector, the crimes affecting the private sector, whether they be internal or external breaches, they're not being disclosed to law enforcement. And but we've created this entire realm of private sector investigation. So, when I meet with law enforcement and I talk to them about how we conduct investigations and our focus on technology and how we are technology enabled in how we conduct our investigation, there is a degree of envy in terms of we do that. I saw an earlier question that talked about or asked a question around, so what does a private sector investigative group look like? So I can't speak for everybody, but only speaking for ourselves. And that means you have forensic accountants like myself. We have people that were trained as lawyers, don't practice as lawyers anymore, but people that were trained as lawyers. We have engineers. We have computer forensic specialists. We have what we call financial crime analytics specialists, who are data scientists that do nothing but focus on fraud and financial crime. And then we also have people that are practiced in dark web, deep web, surface web analysis, so we have a whole cadre of people that do nothing but live in the world of social media, for example. So, you combine all of that together, that's a lot of data. So you need a technology-enabled solution to manage your way through it. But we're well funded, and we're well funded because the private sector is basically mandating us to become well funded and grow through an economy of scale to be able to manage these very large, complex investigations. I'm not saying it's the answer. I'm not advocating that that's the answer going forward. It's the reality in which we live.
Yeah. I'd just love to hear what Carolyn has to say with regards to this issue. I saw her smile when the word envy came out.
Well, I think, I mean, in the private sector, you get to control your own investigation, right? And so if you want to spend more money on that and develop the resources towards that, then you do that. When you switch over to the public sector, it's not the same. There's also, obviously, the public sector has to work within the constraints of the charter, right? So there are certain things that police are able or unable to do, which would probably at times feel very frustrating to somebody in the private sector who is used to a situation where they are able to put whatever resources they want and essentially have free reign over their investigation. So there's a balancing act that occurs there. I have seen, cases where the private sector or a company will do their own investigation and then bring it to a policing service to explain what had happened. So it does occur. I think that, as I said before, there's obviously underreporting of those types of crimes, but it does occur from time to time. There's also, when it comes to prosecuting a case like that, what a prosecutor might know to be the rules of evidence in criminal law might not have necessarily made its way into that private investigation. So whereas you might have a representative from a company who can rely on information they receive from many other sources, you then end up in a criminal case in court, and you want to be careful that you're not relying on hearsay, which would be inadmissible. So there's a lot of partnerships that have to be done and continued and fostered within the private sector, because I do think there is a lot of benefit to working together and fostering those types of relationships. But I think that both sides have places where it's easier for them to conduct their investigations and places where they are constrained by what they're allowed to do.
Sure. Paul, any thoughts on this? You straddle both worlds?
Yeah, I imagine having lived in both worlds, and it's interesting to see the perspective from both sides. It's almost a bit like a house of mirrors when you're in one side and you switch over. I agree with Peter and Carolyn on both issues. I think, yeah, Peter describes accurately kind of what to expect in the private sector investigative world, similar to our business, those kind of different skill sets. And Carolyn, very true. We had the clients where we've done the internal investigation, or usually they start first, and then we come and do a second sort of outside internal. And we've had clients who decide to turn over the files of police, and yet then there's issues often about how evidence is obtained, and we know that going forward. So with my background in law enforcement, actually I'm very honest, and I'll tell the investigator, well, there's this issue, you might see concerns with that issue, and so I speak the same language. But one thing really interesting I found is being out in the private sector is the intelligence. Most of our work is prevention. 7 to 8% of our work is pre-M&A, pre-investment prevention. People want to buy a company, invest, and they don't want to get in bed with organized crime in the worst scenario. And so that's really been interesting for me to see when I'm out of the police, and the police have all these databases that you can access, who's a criminal, who's not, and who's been bad, and who's been good. And here in the private sector, you can't do that. You have to only use the tools that are out there. And it's really muddy. it's like Peter mentioned, it's different province to province, and we do cases all over the world. Every location is different. But what I've seen is being able to cultivate really strong analysts. We have some really good people. We have one, she's a former lawyer, worked in art theft in Europe, former journalist as well. Except that these incredible skill sets, again, with time, even if you don't have access to just those restricted databases, you can still get, in a lot of cases, more mileage and make more links than we even could in the police, which really surprised me. Really surprised me. People often think, it's easy with a magic database. I'll just punch the name and it'll all come out. That's like CSI stuff. In the real world, you got to work and you got to use brain power. All these magic software programs, I'm not sold on most of them. I think it's brain power, and it's been nice to see that in the private sector, how we can develop that brain power, which we didn't have a lot of times in the policing world, which is kind of unfortunate.
Mm-hmm. So I think that we have one more question. Well, we have a few more questions, but one more question that looks at, which I think is it's an issue that has actually come up in numerous discussions in which we talk about accounting firms, the role of accounting firms in the law, and the role of lawyers. And the possibility of certain enabling or wrong disposition in order to stop money laundering or other type of activities. So the question is from Jean-Pierre Chabot, and it is, what about the issue of accounting firms being auditor and advisor simultaneously? Does this reduce the likelihood of accounting firms developing the right disposition?
So can I let Carolyn answer that? So I'm going to preface my response to say that I'm speaking for myself. I'm not speaking on behalf of Deloitte. So I would say that when I started my career, so all those many years ago, it was not uncommon for accounting firms, especially where we were doing the audit, that where a fraud or was alleged or a financial crime was alleged, that we would not also go in and do that investigation. Sarbanes-Oxley changed that for publicly traded organizations. And then further down the path, more organizations have become much more cautious in terms of having their auditors also do the investigations as well. I would say, I'm not saying it never happens, but it is extraordinarily rare that we would both be the auditors and we would be doing an investigation. And I would, I don't see that often, and not only for ourselves, but for any other firms as well. So it doesn't happen that often anymore. And I know that, I don't know if people are following the news out of the UK, but there is more and more regulatory changes coming for the accounting world, where you're sort of put in a box. If you're the auditor, you're put in a box as the auditor, and you're not doing any other advisory services. And I think there is likelihood that that could be cascaded around globally. So I think that this is a question that certainly in history could be perceived as a conflict of interest, but that is changing, and that is changing every year that goes by. And these sort of walls are set up between those entities where companies are doing the audit and those entities where they're doing investigation or other advisory work for them. So I hope that answers the question, but that's likely the way we're headed right now.
Any other thoughts on possible professional designations being enablers?
Well, it's an issue. I mean, I saw it when I was in the RCMP. We had lawyers involved in money laundering. That's one. I think recently we saw real estate agents as well, in terms of all the money laundering going through our cities in the real estate market. So it's an issue. Yeah. I think, to me, I've had cases where lawyers involved, and I always, well, there's an exception there in the law, which is committing a crime. And it can be tough to work around that, but I was able to in some cases. The whole issue about reporting funds, I think, has to be looked further. That is one. I think it's going to come to some point where it has to be examined, maybe changed, where lawyers using as in-trust accounts or whatever are not subject to the same rules in terms of reporting financial transactions. So that's a piece that has to probably improve. Yeah.
My answer would be brief.
There are different competing. No, there are different competing interests with that as to whether or not lawyers should be required to report. And I don't need to go further into that. I think that will work itself out as any progress. But I think that we do see prosecutions of lawyers who acted criminally and other people who hold designations. And in fact, when it does come to being held accountable for that, they are held quite accountable. Assuming that there's a conviction. The criminal code has a statutory, requirement that it's an aggravating factor on sentence when you misuse a designation or a license that you had. So there is recognition that people who, are misusing their designations, essentially committing egregious breaches of trust, should be dealt with in a very serious manner.
Sure. Just my answer will be brief on 2 points. Is this that accounting firms are covered by the money laundering legislation in Canada. So we are required to have systems and processes in place to counter money laundering. And the other answer is, if the question's around, does a professional designation assist you in being a good money launderer? Personally, I think I'd be a good money launderer. Years of experience would have trained me well, but that's a more facetious answer.
Yeah. No, absolutely, absolutely. So our time is almost up. We do have just a few more minutes, and I thought, just to wrap up, as we look at this and we look at Canada's institutional framework, we look at what we have, we look at all that we have, the new institutions that we have created, we look at the problems that we've talked about and the weaknesses that we've discussed. What would you say are sort of the top 3 action points that you would like to see as an outcome of to try and embark on a stronger institutional framework in Canada? So your top 3 points. Anyone can start.
I can start. Look, I mean, I think that the SFO is really trying now. I think that we have positioned ourselves in a way to be the answer to all of these problems. The fact that we are holistic and the fact that we are embody a different framework that has been before, and there really is the institutional desire to prosecute these cases. I mean, you have experienced people who have chosen to work in a specific niche area of the law. Really bodes well for the future for us.
Excellent. Thanks, Carolyn. Paul or Peter?
So I'll go second, and that's basically, again, a public registry of beneficial ownership. I think structurally that is something that would really move the yardsticks forward in Canada. I'm not saying it's going to be an easy task to work through. A lot of effort and research has gone into this, not only by TI Canada, but many other organizations, but kudos to TI Canada. The one comment I would have for Carolyn, yes, the SFO is a great step forward. And maybe it can be used in other provinces, but it has to be, personally, I think we have to set up something nationally that cuts across these interprovincial boundaries and barriers that we have in place structurally. So and again, a registry around beneficial ownership can be the start to that in terms of gathering the data and intelligence necessary to fight many of these offenses.
Well, I'm an optimist, and I think that there is hope for Canada. It's a great country, and I think the people working in the field are smart people, and they want to get things to a point where we can be more proud of results. I would like to see, building on what Peter said, and some sort of more of a national, whether it's a separate structure or a firewall with the rest of the RCMP, some national structure where experience is cherished, is valued, is promoted, and with that, we can see these specialized units as well, like Carolyn Scott or UPAC. I think that's what we have to go to. And we have to go there better sooner than later if we're going to remain one of the best countries in terms of our enforcement capacity. The intelligence piece is another piece too, I think we have to upgrade, is whether it's, we haven't gone and talked about FinTrack and other sources of intelligence, but I think there's work that be done there as well to upgrade our capacity.
Well, once again, thank you so very much, first of all, for participating and for a great, super lively debate. I'd like to now turn the word to James.
Great. Thank you very much, Daniela, for moderating an excellent panel. And thank you to Paul Garside, Carolyn Hackett, and Peter Dent for joining us today. And I saw a very active commentary in the chat box, which is excellent. It is called the Day of Dialogue, and so we do want people to participate and share their ideas. I'll just say once again a thank you also to our Platinum supporters, Export Development Canada, our Gold supporters, Banque Nationale, or National Bank of Canada, Blake's, BLG, Deloitte, Denton, Siemens, Skypower Global, and our Silver supporters, ACFO, Elisa, Kinross Gold, KPMG, Vidocq Group, and Thales Canada. And as I've been putting into the chat box, if you'd like to make a donation or become a TI Canada member or become a TI Canada supporter, you can do so on our website. Thank you very much to our previous TI Canada Chair and President, Paul Lalonde, for his offer on matching donations. If anybody missed that, you can I think I might extend the deadline just ever so slightly. Paul, forgive me for extending it, that people could make donations to match if you saw Paul Lalonde's message within the chat box. We have a great week still to come. We were talking about institutions today. Tomorrow we'll get further into the issue of tools that we'll be talking about that we have available to our law enforcement. Oh, I just saw a donation come up. Thank you very much. Then Thursday, we'll be looking at lessons from abroad, how we've been looking at the subject. And then finally, Friday, we'll bring a number of panelists back together and look at what we've learned from over the week. So once again, thank you to our panel today. Thank you to Daniela for moderating, and thank you for everyone attending. Looking forward to seeing you all again tomorrow. Have a good day, everyone.
Thank you
Thank
very
you.
much.
Thank you.
Thank you. Bye-bye.